Good morning, everyone. Welcome to the ELU. We're just going to give it a minute or two just to allow people to join, and then we'll get going. Morning, everyone. I think we've got enough people who have joined to get going. Welcome to the Employment Law Update. This is our second Employment Law Update for the year. As usual, we are not short of what we hope you find to be some interesting employment law cases, some recent cases impacting the employment law landscape in South Africa. My name is Helen Wilsenach. I will be facilitating this morning's update. I'm joined by my colleagues in our employment and benefits practice area. I will introduce you to them as we go along, but for those of you who are regulars to our ELU, I think many people here will be familiar faces to you. Before we begin, I would just like to run through some very short housekeeping matters, which will hopefully enhance the webinar experience for you. As participants, you are automatically muted and the chat functionality has been disabled. But if you've got any questions, if you could just pop them in the Q&A tab at the bottom of your screen, we will monitor those and we'll try and address as many of those as we can as we go through the cases. We won't be providing written responses to Q&As, but the webinar is being recorded and will be made available on our website after the update at www.bowmanslaw.com. In addition, as has been our practice the last few updates, we will be sending you a high-level summary of the cases discussed this morning with the key takeaways and the principles highlighted for you, and we'll aim to get the summary to you early next week. So without further ado, welcome. We've got 10 cases for you today, so we should hopefully finish very comfortably within the allocated time. Soraya, an associate in our employment law practice, is going to kickstart our first, the AMCU case, a case which I think deals with unfair discrimination. Well, I know deals with unfair discrimination, but which I think underlines how difficult it can be an unfair discrimination claim based on an arbitrary ground across the line. Thank you, Soraya.
Thank you so much, Helen, and good morning, everyone, for being here. So as Helen mentioned, I'll be dealing with the AMCU OBO members versus Aberdare Cables labor appeal case. And this concerned an equal pay dispute under Section 6(4) of the Employment Equity Act. So AMCU alleged that Aberdare fairly discriminated against 35 of its members by paying them less than other employees performing the same or similar work, comparator employees. And Aberdare operates within the Metal and Industries Bargaining Council, the MEIBC, which regulates the conditions of their employment in the industry by means of a collective agreement concluded at the industry level, which fixes the minimum wage at the level. But historically, Aberdare paid its employees at a higher rate than that prescribed by the MEIBC. And then what happened is that on 8th of March 2013, Aberdare initiated a retrenchment process. And during the ongoing consultations with the authority union NUMSA, they explored three possible options. The first was a wage freeze. The second was the commitment of the process of retrenchment. And the third was an agreement that new employees employed by Aberdare would be paid at the prescribed MEIBC rate as opposed to the employer's higher rate. And this was to allow natural attrition to ensure that at times all employees would be engaged on the same rates of pay in the future. So NUMSA and Aberdare agreed to the third option, to secure the company's future financial viability and to avoid job losses. So as a result, all employees employed after the 1st of 2014, including the affected AMCU members, were paid at the lower prescribed rate of the MEIBC, created an ongoing wage differential between the pre- and post-2014 employees doing the same or similar substantial work. So then in 2019, the appellants referred a dispute to the CCMA, contending that Aberdare was in contravention of 6 of the Employment Equity Act because there was a difference in terms and conditions of employment between its members and the comparators. The dispute could not be conciliated and was referred to arbitration. And at arbitration, the appellant stated that the ground upon which the differentiation was based was solely on the fact that Aberdare elected to pay a higher remuneration than the minimum wage provided for in the MEIBC collective agreement, but had irrationally and arbitrarily elected to do so only with respect to the comparator employees. So the arbitrator accepted Aberdare had introduced the new wage rates with the consequences of a differentiated wage rate between existing employees and those engaged in, with the agreement of NUMSA, the majority union at the time, as a means of addressing operational requirements that would otherwise result in job losses. And the arbitrator concluded that the decision by Aberdare did not discriminate on the fundamental dignity of employees, and it was rational and justified. The matter then went on to the Labour Court, and at the Labour Court, an order to the effect that Aberdare had discriminated against its members in contravention of Section 6 of the EEA on an arbitrary ground. And the Labour Court dismissed the appellant's matter on the basis that the appellant had failed to establish that the reason for the wage negotiation is some characteristic that impairs human dignity. And in coming to this conclusion, the court applied a narrow approach as adopted in the case of Nadu versus Parliament of RSA, and held that a claimant relying on Section 6 of the EEA must demonstrate more than a mere differentiation. So when you rely on any other arbitrary ground, it requires a claimant to specifically identify and plead a ground of discrimination that is analogous to a listed or special ground of discrimination in the sense that it has the potential to impair upon human dignity in a comparable manner or have a similar consequence. Then, at the Labour Appeal Court, the appeal focused on the application for the test for unfair discrimination. The appellants had properly pleaded in their case. And in order to find unfair discrimination in a pay dispute in terms of Section 6(4)(a), it obviously requires showing that the work being performed is the same or similar of an equal value, and that the wage based on a prohibited listed ground or an arbitrary ground. The court also considered Section 11(2) of the Employment Equity Act, which is the burden of proof when relying on an arbitrary ground, and requires determination on a balance of probability as to first, whether the conduct is irrational, whether it amounts to discrimination, and whether the discrimination found can be established to be unfair. The Labour Appeals Court view, the appellants failed to establish the first hurdle, that Aberdare's conduct was irrational, i.e. being that rationally and arbitrarily elected to apply the higher MEIBC wage rate only with respect to the employees, the existing employees. The court said that rationality is concerned with the relationship between the means and the ends, relationship between the means selected to achieve a particular purpose on the one hand and the purpose itself on the other. Acknowledged that the reason for the differentiated wage rate were sound operational reasons. For the decision that Aberdare had circumstances to address its financial difficulties and to save jobs. In any event, the Labour Appeal Court said that the second by the appellant could not be established, as it required proof that by the appellants that the wage differentiation discrimination, the sole arbitrary ground relied on by the appellant in support of its claim, was that the employer irrationally and arbitrarily elected to apply the higher wage rate. The LAC stated that there was no proper arbitrary discrimination pleaded. In the Labour Court and in the current Labour Appeal Court proceedings, the appellants tried to introduce nuance. They contended that the arbitrary ground on which it relied on was the employee's date of employment, being the 1st of January 2014, the date that the lower rate began to be paid. And the LAC found difficulty in finding that it can be said that a particular date of employment can constitute an arbitrary ground for the purpose of an unfair discrimination claim. Finally, the Labour Appeal Court said that even if discrimination had been established by the appellants, it could not be established that such discrimination was unfair. And the Labour Appeal Court went on to consider Regulation 7 of the Employment Equity Act Regulations of 2014, which contemplates a number of circumstances in which a difference in terms and conditions of employment is not unfair discrimination. So the practice of retaining an employee or a group of employees on existing terms and conditions of employment, while different terms and conditions of employment apply to future employees, colloquially referred to as grandfathering, is not uncommon in our human resources management, and it is similar to the circumstances envisaged in Regulation 7. And this is a temporary mechanism often introduced by employers. As such, the appeal was dismissed. So I think, what are the main key takeaways of this case? So the importance of clear and precise pleadings in discrimination claims. So when you rely on an arbitrary ground of discrimination in an unfair discrimination claim, in terms of the Employment Equity Act, it is now well established that the narrow interpretation applies, and a claimant seeking to establish discrimination on this basis must identify the ground of discrimination, as opposed to making a generalized statement saying that it is arbitrary. Such an arbitrary ground must be based on attributes and characteristics which have the potential to impair the fundamental human dignity of persons or affect them adversely in a comparably serious manner. Thank you so much, Helen.
Thanks, Soraya. So I think that's building on what's now becoming quite a long line of cases in terms of dealing with arbitrary grounds of unfair discrimination. And I think the takeaway, Soraya said, it's quite a difficult onus to discharge for an applicant, and also good to know that grandfathering, just an affirmation that grandfathering is an acceptable practice. Pivoting now to legal representation in the CCMA, Mbali, who's an associate in our practice area and who spends quite a lot of time litigating the CCMA, so this is something close to home for her, is going to take us through a recent case, a Fraser Alexander case, dealing with when legal representation is permitted. Thanks, Mbali.
Thank you very much, Helen. Good morning, everyone. The case of Fraser Alexandra Pty Limited versus the Commissioner and the CCMA was a review application that was brought up by Fraser Alexandra against a Commissioner's award where the Commissioner had found a employee's dismissal to be substantively unfair and awarded the employee reinstatement with 4 months back pay. I won't spend too much time on the facts of this matter, but just touching very briefly, the employee was dismissed following an internal disciplinary hearing where the internal disciplinary hearing chairperson found that because the employee had been dismissed previously on 2 occasions for the same or similar misconduct, that the appropriate sanction in this case would be a dismissal. Now, Fraser Alexandra's grounds of review were based on Section 145(2)(a)(1) of the Labour Relations Act, and that the Commissioner had misconducted himself during the CCMA proceedings. In its ruling, the Labour Court spent quite some time dealing with the reasonableness ground of review that is found in the Sidumo case by the Constitutional Court. But for present purposes, I won't spend too much time dealing with that, but I will want to spend a lot of time dealing with the latter part of the Labour Court's ruling. And just to stop there, the court stated that the reasonableness test that is established by the Constitutional Court in Sidumo does not replace the grounds of review that are statutorily prescribed by Section 145 of the Labour Relations Act. And this means that when it comes to the Commissioner acting outside of his powers or committing a misconduct during the proceedings, thereby depriving a party of a fair hearing, the issue of reasonableness or a reasonable outcome becomes irrelevant. And in such instances, the reviewable defect is found in the actual existence of the statutory prescribed review ground, and the award cannot be sustained regardless of what the outcome of the award may or may not be. The court gave examples of this, and the examples included where a Commissioner should have granted legal representation but did not do so, or where the Commissioner's conduct constitutes bias or prevented a party from stating its case and thereby depriving the party of a fair hearing. Now, in this particular case, Fraser Alexandra based its grounds on 2 instances. Firstly, that the Commissioner had misconducted himself by allowing the employee's legal representative to be present during the conciliation proceedings. And secondly, that the Commissioner granted legal representation during the arbitration proceedings in the absence of a application having been made on behalf of the employee for a legal representation. And the court stated that in cases where the ground of review is based on the Commissioner's misconduct, the outcome of the award based on reasonableness or the reasonableness of the outcome becomes irrelevant. The court stated that the applicant must point to specific unfairness arising from the action of the Commissioner in order for a proper ground to be established. A failure by the Commissioner to conduct the proceedings fairly will have the effect that one of the parties will not receive a fair hearing, and which will inevitably almost always lead to the Commissioner having committed a misconduct or a gross irregularity during the proceedings. One of the key takeaways that one must take away from this was the principle that the court discussed in terms of how to decide whether or not the Commissioner had misconducted himself. It's a 2-staged inquiry. Firstly, we consider whether the Commissioner's conduct indeed could be considered to have been unfair, and if so, whether such unfair conduct had the actual effect of depriving the applicant of a fair hearing. And if both of those questions are answered in the affirmative, then the Commissioner committed a misconduct. In this particular case, when looking at the presence of the employee's legal representative during the conciliation process, the court stated that the limitation placed by Section 135(4) of the Labour Relations Act of the persons that may be present during the conciliation process is peremptory, and it cannot be departed from either by agreement between the parties or by waiver by either of the parties or by both. And therefore, even if the commissioner mistaken the identity of any individual present during the conciliation process or his or her designation, then that mistake, even on its own, is a reviewable irregularity. In this particular case, the court found in favor of Fraser Alexandra and found that in this case, the employee did not deny the fact that his legal representative was present during the conciliation process. And secondly, there was no evidence put before the court to state otherwise. The court accepted the applicant's version and said that the fact that the commissioner allowed the employee's legal representative to be present during the conciliation proceedings constituted a reviewable irregularity. Now, turning to the second aspect that was brought forth by the applicant, and that is the commissioner allowing the employee to be legally represented during the arbitration proceedings in the absence of a formal application having been brought by the employee or his representative. Interestingly, the commissioner at the beginning of the proceedings gave the parties an opportunity to address him on any preliminary issues that they wanted to address before the beginning of the arbitration proceedings. And interestingly, it was the employer's representative that raised the question of legal representation and not the employee. And when the employee's legal representative was given the opportunity to address the Commissioner on Legal Representation, he merely stated that the matter was a complex matter and that it raised issues of law that the employee would not be able to deal with. When assessing this, the court found that a formal application for legal representation was actually never made, and nor did the employee's representative deal with all of the aspects that must be addressed in terms of Rule 25 of the CCMA rules when bringing an application for legal representation. And when the commissioner allowed legal representation, he stated that his ruling in that regard will be contained in the CCMA Arbitration Award. The ruling was actually never contained in the award, but instead, in the record of proceedings in the CCMA was a ruling titled Legal Representation and Postponement Ruling. The ruling was evidently never sent to either of the parties. They never received it, and nor was it signed by the commissioner. So the court did just make a note as to what the status of that particular ruling was. In the ruling, the commissioner stated that prior to the commencement of the arbitration proceedings, a formal application was filed. Obviously, an application was never filed, and he stated that he was granting legal representation on the basis that it would be unreasonable to expect the employee to deal with the dispute without legal representation, and that is only on the basis of the comparative abilities of the employer's representative in comparison to the employee. However, he also stated that he was not persuaded that the matter was complex, nor was it in public interest, nor did it raise any questions of law. The court found that the commissioner, in granting legal representation, based his findings on evidence that was never led during the proceedings, because comparative abilities was never something that was conversed by either of the parties during the proceedings, and thus his reasoning was unrelated to the evidence that was led. The court reiterated and cautioned the principle that a commissioner's discretion to allow legal representation is a discretion that must be exercised judicially. In this case, the court found that the commissioner's exercise of his discretion was exercised in a mala fide and capricious manner, or in a manner that cannot be considered to be judicious. The court further noted that it was even more concerning that in granting legal representation, the commissioner did not give the employer an opportunity to also obtain legal representation in order to level the playing field. The court found that once the commissioner had properly applied himself and to all of the factors in Rule 25 and had reached the conclusion that legal representation was appropriate, he ought to have given the employer the opportunity to also get legal representation, and that his failure to do so rendered the proceedings procedurally unfair, particularly given the fact that it was evident that the employer's representative at the proceedings was not legally trained, and nor did he have any experience in dealing with CCMA matters. The court therefore found that the commissioner's conduct in failing to give the employer an opportunity to be legally represented rendered the proceedings procedurally unfair. Now, we move on to the second test, which is whether that unfair conduct actually deprived the employer of a fair hearing. The court held that in this case, it was clear that the employer's representative was a layperson with no legal experience, and this was shown by the record itself. The court found that the commissioner's failure to recognize that pitting the employer's representative against a legal representative on behalf of the employee was unreasonable and deprived the employer of a fair hearing, and therefore the commissioner had committed a misconduct. The court found that the commissioner committed a misconduct, and his conduct constituted a gross irregularity as contemplated by law. Ultimately, the court found that regardless of the merits of the award, the CCMA award failed to be reviewed because the proceedings were vitiated by the commissioner's conduct. The court concluded by saying that at the moment that a party is deprived of a fair hearing, that is the end of the matter, and the award emanating therefrom must be reviewed and set aside regardless of the merits of the matter. The court therefore granted the review and remitted the matter back to the CCMA for hearing de novo. Just briefly, there are just 4 takeaways that one should take away from this case. Firstly, is that the grounds of a review that are set out in Section 145 of the Labour Relations Act are not taken away by the reasonableness ground found in Sidumo. Secondly, when we are looking at the commissioner's conduct in order to establish misconduct, we first look at whether his conduct was such that it could be considered to be unfair, and if such unfair conduct, and if that unfair conduct had the result of depriving the applicant of a fair hearing, then the commissioner misconducted himself, and therefore the reasonableness of the award therefore becomes irrelevant. Thirdly, the prescribed persons that may be present during a conciliation process in the CCMA is peremptory, and only those persons may be present, and the failure of the commissioner to notice that there's anyone present in the room that is not one of the prescribed persons, that in itself constitutes a reviewable irregularity on the part of the commissioner. And finally, which is an established principle, that the commissioner must exercise his discretion judicially when deciding whether or not to allow for legal representation, and he must take into consideration all of the factors that are provided for in Rule 25 of the CCMA rules. Thank you very much, Helen.
Thanks, Mbali. I think that's a useful case. I think sometimes a bit of a laissez-faire approach has crept into the CCMA hearings. I know when clients are not always sure who's in a conciliation. So I think that case is to be welcomed, and I think it's also just a warning for employers and employees alike. Obviously, the worst case outcome is to go through all that cost and expense and time to end up back in the CCMA with a rehearing. So just the importance of understanding and adhering to the CCMA rules. Nadine, who's a very familiar face to many of you, our partner in our practice area, will be taking us through our next 2 cases. Both of them dealing with dismissal, but the one relating to a employee who was a foreign national, and the second one looks at the question of how much leeway does an employer have when requiring an employee to return to work, an employee who's been working remotely, so dealing with very different subject matter. Thanks, Nadine.
Thank you very much, Helen, and good morning, everyone. The first judgment I'll be discussing today concerns the dismissal of an employee over a lapsed work permit and highlights the complex interplay between our immigration and employment laws. Now, in this matter, the employee, Samuel, was a Zimbabwean foreign national and was employed by OR Tambo District Municipality as a research assistant. He was employed on successive fixed-term contracts from 2009 to March 2022. And after the expiry of his last fixed-term contract, the municipality allowed the employee to continue working without a new fixed-term contract. Now, during the course of his employment, the employee was not always in possession of a work permit. In fact, it was only in 2012 that the employee was granted a general work permit, which work permit was subsequently renewed and expired in 2018. Now, in November 2023, the municipality issued the employee with a termination letter, informing him that his fixed-term contract had expired in 2022, that his contract was based on his work permit, and that the employee had failed to provide the employer with a copy of his South African identity document after being requested to do so by the Auditor General. The municipality advised the employee that it was left with no option but to terminate the employer's employment contract with immediate effect, as the contract was unlawful and irregular. Now, whilst the employee could have challenged his dismissal before the CCMA, the employee elected instead to approach the High Court to challenge the termination of his employment. The employee argued that the termination of his employment contract without notice was wrongful and unlawful, and he requested reinstatement together with a cost order. Now, the municipality, of course, opposed the application on the basis that, notwithstanding that the employee had worked past his fixed-term contract, and this was due to an oversight of personnel, the termination was necessary to rectify the position as the employee's work permit had expired. So the issue for determination before the High Court was whether the termination of the employee's employment was unlawful, and if so, whether the employee was entitled to be reinstated. Now, the court noted that the Immigration Act regulates an employer's duties and obligations in relation to the employment of foreign nationals. And in this regard, the Act provides that no person may employ an illegal foreigner or a foreigner whose status does not authorize them to be employed by such person, or a foreigner on terms and conditions or in a capacity different from those contemplated in respect of the foreigner's status. Now, further, the Act imposes an obligation on an employer to make a good effort to ascertain the status or citizenship of those whom it wishes to employ. And if an individual is employed in breach of the Act, it is presumed that the employer knew at the time of employment, unless the employer is able to demonstrate that it took the necessary steps to ascertain the employee's or the individual's status. Now, should an employer employ a foreigner in violation of the Immigration Act, this constitutes a criminal offence which is punishable by the imposition of a fine or imprisonment upon conviction. So with reference to these provisions of the Immigration Act, the municipality, of course, argued that it was prohibited by law to continue employing the employee, and consequently the termination of the employee's employment was lawful. However, the High Court noted that the municipality had overlooked the right of employees not to be unfairly dismissed. So whilst an employer may terminate an employee's contract due to legal incapacity, it may only do so in a fair manner. So the laws governing fair labour practices and dismissals apply to all individuals, regardless of their legal status. So in the present matter, it was clear from the termination letter that the employee's employment was terminated as a result of a lack of a work permit or identity document. And the court found that being an illegal foreigner alone does not automatically grant an employer the right to summarily terminate an employment contract. The proper processes and the legal grounds for termination as set out in the Labour Relations Act must still be followed. Now, turning to the issue of the summary termination, the court also had regard to the provisions of the Basic Conditions of Employment Act, specifically in respect of the manner in which it regulates notice of termination and the minimum notice periods. It explained that the primary purpose of providing an employee with adequate notice is to ensure, at least prepare the employee for a smooth transition. Now, it was common cause in this matter that the municipality had given no notice, let alone adequate notice, to the employee of the termination, and this contravened the provisions of the BCA. So based on the evidence provided, the court found that the termination of the employee's employment was in fact unlawful. Turning to the question of whether the employee should be reinstated, the court noted that the Labour Relations Act prescribes that reinstatement is the primary remedy unless it is intolerable or impracticable. Now, the municipality in its answering papers contended that the position held by the employee no longer existed in its organizational structure, and the employee failed to counter this claim in its replying papers. So on this basis, the High Court deemed that reinstatement would be impracticable, and there was no alternative relief such as compensation that had been sought by the employee. So the court accordingly held that the termination of the employee's employment was unlawful and ordered the respondent to pay the costs of the application. I appreciate that the relief to the employee may have been different had the employee approached the CCMA in respect of an unfair dismissal as opposed to the High Court, but that was the order handed down by the court. So just in respect of a few key takeaways, this judgment, of course, reiterates the principle that the constitutional right to fair labour practices applies to all individuals regardless of their legal status or right to work. So the right extends to foreign nationals, even where they are employed without a valid work permit, meaning they enjoy equal protection under our employment laws. So accordingly, in circumstances where an individual is found to be employed without the required work permit, or they are entitled to work beyond the expiry of a work permit, this does not mean that the contract is automatically invalid or it lapses or the employer has a right to summarily terminate the employee's employment. Doing so would cause risk to the employer in respect of either an unfair or unlawful dismissal claim. So, of course, the fact that an employee does not have a legal right to work in South Africa would, or at least would be a fair reason in which to terminate the employment, but the employer would be required to follow the necessary processes. Depending on the circumstances, the most appropriate route would arguably be an incapacity dismissal, as the lack of a valid work permit impacts the employee's legal capacity to perform their job. Where the employee is dismissed following a fair process, the employer should also provide the requisite notice as provided for either in the contract or the BCA. And of course, in these circumstances, it may be appropriate to treat the notice and pay in lieu of notice specifically. And lastly, the judgment just reiterates the importance of diligent record keeping. Employees should be employed on fixed-term contracts which align with their relevant work permit, and such contracts should not be renewed or at least rolled over until there's confirmation that the work permit has been renewed or the employee has obtained a new work permit. So before I move on to my second judgment, we are going to put up a poll as part of the webinar, which we would appreciate your feedback on. And this is really for those employers who have had remote or hybrid working arrangements. The question we will be asking is whether your organization has recently implemented or at least are considering implementing a return to office policy. So hopefully the poll will appear shortly, and we will just give you a moment to participate in the poll, and we look forward to receiving your feedback. Please just bear with us for a moment. So whilst we are just completing the poll and considering feedback, since the COVID-19 pandemic, I think many employees whose duties allow for it have been allowed to obviously continue working remotely, either on a permanent or hybrid basis. However, some employers have taken the stance, or the decision at least, to terminate those working arrangements and to require employees to come back to the office. So the next judgment I will be discussing concern the fairness of an employee's dismissal as a result of the employee failing to comply with an instruction to return to the office. Now, in this matter, the employee, Ms. Rue, was employed by Medici Energy as a sales executive. And during the COVID-19 pandemic, and for over 2 years, there was an arrangement put in place that allowed Ms. Rue to work from her home in Paarl for reasons relating to her son's autoimmune disease. Now, in May 2022, Ms. Rue requested the employer's formal grievance document and indicated that she wished to submit a grievance against 2 managers. Her request was ignored. In June, Ms. Rue repeated her request for the grievance documentation from the HR manager, and the very next day, without any prior consultation or warning, Ms. Rue was issued with an instruction to return to work from the office with effect from the following Monday. Ms. Rue did not return to the office, and she elected to ignore further instructions from the employer to return to the office. So as a result, Ms. Rue was dismissed following a disciplinary hearing in respect of gross insubordination relating to her failure to comply with a lawful and reasonable instruction to return to work in the office. Ms. Rue challenged the fairness of her dismissal at the CCMA, and the CCMA Commissioner found that, on a balance of probabilities, the instruction to Ms. Rue to return to the office was in response of her intention to submit a formal grievance. The evidence demonstrated that there was an agreement for Ms. Rue to work from home. Why, suddenly, long after COVID, did Ms. Rue working from home become so untenable? The Commissioner found that whilst the instruction may have been lawful, the instruction was not reasonable, and consequently, it held that Ms. Rue's dismissal was both substantively and procedurally unfair, and awarded her compensation equivalent to 8 months' remuneration. Aggrieved by this decision, the employer took the arbitration award on review to the Labour Court, and it argued that it did not meet the reasonableness standard. The review application was unopposed. Now, the Labour Court considered whether the Commissioner had committed any reviewable irregularities or at least arrived at an unreasonable conclusion. And ultimately, the Labour Court found that there was no merit to the employer's review application, and the CCMA Commissioner's conclusion was more than justified by the evidence. Now, in this regard, the evidence revealed that there was an arrangement in place which allowed Ms. Rue to work from home. The instruction to return to the office referred to a decline in COVID-19 cases as the ostensible reason for the instruction, but this was not substantiated by any evidence put forward by the employer, nor did it justify the termination of this long-standing arrangement in place with Ms. Rue. One would have expected a pressing reason in which to terminate the arrangement, and no reason was forthcoming from the employer. It was also not reasonable to require Ms. Rue to return to the office effectively on no notice. This could only really have been calculated to prejudice Ms. Rue. The timing of the instruction was damning. Ms. Rue had indicated her intention to lodge a formal grievance, and the very next day, Ms. Rue was issued with an instruction to work from the office. And there was no plausible reason offered by the employer to suddenly terminate the working arrangement. The only reasonable inference in this matter could have been that the instruction was issued in retaliation for her intending to submit a grievance. And lastly, Ms. Rue's dismissal was in fact predetermined by the employer. It was found in the evidence that there was an instruction from the employer to its labor consultants to terminate the working relationship with immediate effect. And the notice to attend a disciplinary inquiry was issued to Ms. Rue the next day. So having regard to this evidence before the commissioner, the court found that the conclusion that the instruction was not reasonable and consequently that the dismissal was substantively unfair was one that a reasonable decision maker could reach. Briefly, and turning to the issue of procedural unfairness, again, the court found that the commissioner's findings were also reasonable. There were findings that the employer had refused to give Ms. Rue certain details relating to the allegations of misconduct, and Ms. Rue was also prevented from using her chosen representative to represent her at the hearing, which was apparently on the false basis that the representative may be a potential witness at the hearing. So the court thus found that the employer had not made out any case which justified interfering with the arbitration award on review, and the application was dismissed with no order as to costs. So in terms of key takeaways, and whilst I appreciate that this judgment concerned an instruction to return to work which was in retaliation against an employee seeking to lodge a grievance, should employers wish to change their existing arrangements relating to remote or hybrid working and to revert full-time to office working, any instructions in this regard must be reasonable. And in order for the instruction to be reasonable, it must be based on specific reasons relating to the employer's operational requirements that justify return to the office. It is further advisable to provide these instructions in a manner that allows for a form of consultation. This will ensure that employees have the benefit of at least asking questions or interrogating the reasons provided by the employer in respect of the change to the working arrangements, which may assist, of course, in mitigating any risk of unfairness claims. And as part of this, of course, careful consideration should be given in respect of whether these instructions are going to amount to a change in terms and conditions of the employee's employment, in which case the employee's consent would be needed in order to effect a change in their working arrangements. Thank you very much.
Thanks, Nadine. Yes, it's just as easy as issuing an order if there's not a contractual right to work from home, and that kind of rationality piece, I think, also comes through as your reasons for requiring employees to return. Sticking with the dismissal for purported misconduct, Loé, a partner in our practice area, is going to take you the Sibanye Gold case, which really looks at the question of what constitutes intimidation in the realm of disciplinary charges. Thanks, Loé.
Thank you, Helen. Good morning, everybody. So as Helen said, I'm looking at a case between Sibanye, which is a review application. And in this instance, and as Helen's mentioned, the case revolves around the question between intimidation, what amounts to intimidation, versus perhaps something of a lesser degree of misconduct being undue pressure. So in this instance, what happened, and the factual nexus is quite important in these circumstances, but the employee was employed by Sibanye as a rock drill operator and was also a shop steward representing the Association of Mine Workers and Construction, AMCU. Now, it's very important to understand in the context that there was a strike called by AMCU at the time, and it was quite a very violent strike. There'd been 25 deaths and 25 very serious injuries, and so one has to understand the context and the environment at the time was that there was a lot of tension, a lot of fear amongst employees, and at that time, there was a disciplinary hearing called against this employee, and the subject of the misconduct in this instance was that he had phoned a colleague in the HR department, and he was charged for intimidating and harassing the HR colleague. Now, the incident itself was a phone call made by this employee at 6:30 on the morning to Ms. Moleli, an HR superintendent, who testified that she was shocked to get a call so early. And then what was critical to this case was that he was asking her where she was, if she was already at work, and if she was not, when would she be at work? And this turned out to be central to this case. The call went on, and he asked about certain mine employees who had been paraded by the mine, and essentially was paraded to join other unions. And they had a discussion around that, and Ms. Moleli was asked who it was that had arranged for that, and she was not comfortable disclosing that information because it was one of her supervisors. Immediately after the phone call, Ms. Moleli then reported the incident to her GM and her ER manager, saying that she'd received the threatening call and that she felt she was going to be another victim of the strike, either through very serious violence. And essentially her concern was around this questioning around her whereabouts. What followed thereafter was that her fear was so genuine that they arranged for SAPS patrols to and from work for a month thereafter. And during the strike, actually non-strikers were also attacked on the way to and from work, and houses were burned down. There was a lot of issues that arose from the strike. When this matter went to the disciplinary hearing itself, the employee was found guilty and dismissed for intimidation and harassment. And of course, he was unhappy with this, so he referred it to the CCMA. Now, the CCMA listened to the conversations, and they listened to the discussion because the conversations were recorded, and there was a discussion between they listened to the discussion between Ms. Moleli and the employee. And they said that, well, the commissioner finds that the first question was around how she was, normal greetings, and then the questioning around whether she was already at work sounded like a fair question. That was the wording that was used in the arbitration award. As the questioning continued about what time do you report for work and are you still at home, the arbitrator noted that from the recordings, it was evident that Ms. Moleli was clearly feeling uncomfortable and wanted to know why he was asking this. The employee just said in his evidence before the CCMA that the reason he was asking this was because he wanted to arrange a meeting with Ms. Moleli, and that it wasn't intended to be something intimidatory relating to taking action against her or anything about her whereabouts, as per the strike concerns. Now, the arbitrator, in looking at the matter, said that her feelings of feeling threatened was, under the circumstances, reasonable. So essentially, he said that subjectively, one can understand why she felt threatened. But what he did not accept was that objectively viewed, it was reasonable it would have been reasonable for any reasonable employee to feel that they were being intimidated or threatened under the circumstances. So essentially, the arbitrator looked at two aspects to it. He said, subjectively, he understands why Ms. Moleli was feeling intimidated, but under the circumstances, objectively, a reasonable employee would not have necessarily felt the same. And so he said that the discussion around her being asked also in relation to who had provided the employees to be paraded, that was inappropriate and amounted to undue pressure under the circumstances. But to the arbitrator's mind, the feeling was that, or the outcome was that he did not consider that discussion to amount to intimidation. On review, the matter was taken on review. The argument from Sibanye was that the commissioner had failed to consider material evidence, which led to a conclusion that no reasonable decision maker could have arrived at. They argued that Mr. Molele was clearly scared, which resulted in certain actions thereafter. For example, the employee phoned Ms. Molele again afterwards when it had been brought to his attention. And they said that under the circumstances, on a balance of probabilities, it was more probable that an intimidation did occur and that dismissal was the appropriate sanction. The court evaluated the evidence before him. And the judge said that what was very evident was that the arbitrator clearly applied his mind very carefully to all the facts before him. And so it's one of those cases, the judge said, where under certain circumstances, another reasonable commissioner in the place of the commissioner may have arrived at a different outcome and said that dismissal was appropriate. And sorry, I forgot to mention that in the arbitration, the commissioner ultimately found that the dismissal was substantively unfair, that it was too harsh a sanction, and that a final written warning would have been more appropriate. And so when it was taken on review, Sibanye took it on review and said that dismissal was should have been the reasonable outcome. And so the judge looked at it and said that to his mind, that it was evident that the commissioner applied his mind very carefully, looked at the matter, analyzed the phone calls, and that they looked at the subjective element, but one had to look also at the objective element. And objectively, a reasonable commissioner could have arrived at the same outcome. And it's quite an interesting take, because there's quite a fine line, as the judge himself pointed out, that under certain circumstances, another commissioner may have arrived at a different outcome and found that dismissal was a fair outcome. And one must remember the role of the commissioner is to determine whether the dismissal was a fair outcome and not to impose necessarily their own sanction under the circumstances. And so it raises this question about intimidation versus undue pressure, and the threshold to meet a determination of what is intimidation, which would more than likely be dismissible in many instances, and what falls short of that threshold, and what would be constituted as undue pressure. And in this circumstance, the judge found that the outcome by the arbitrator was one that fell within this band of reasonable outcomes, and therefore did not set aside the arbitration award. The review application was dismissed and no order as to costs was made. Now, we're going to put up a poll. I think it's quite interesting when one factors in the context of the work environment, bearing in mind how violent the strike was, whether under those circumstances one would have arrived at the same outcome as the arbitrator, or whether one feels that he took a good technical approach to it and actually arrived at a reasonable outcome. So we've put up a poll. What do you think of the outcome of the case? Do you agree with it? Yes, I don't think the employee's conduct was serious enough to warrant dismissal, or the commissioner's approach was too technical and the dismissal should have been upheld. I think what's quite useful also in looking at this matter is that generally we are seeing an increase in investigations or matters involving complaints of intimidation against employees in a workplace, potentially against managers. And so this question around looking at the subjective element and objective element to it may play quite a critical role in making those determinations. What falls into the band of intimidation, harassment, versus something that may fall to be a lesser form of misconduct, like undue pressure.
Well, yeah, I feel it's one of those marginal calls where companies and employers may just decide that if they feel strongly about it, to take disciplinary action, because ultimately, I mean, it highlights either on the review test, it's obviously difficult to get something set but it was a very, very, as you highlight, marginal call. Just while we're waiting for the poll, the way I thought it might just be useful, there's one question in the Q&A relates back to the remote working. So I thought we'd quickly just address that while we wait for the poll. And the question is, are there any cases where it was just a blanket return to work, a whole firm, a whole company, and employees have just refused? Kim, to your question, I think we've seen quite a lot of that in the States that have issued kind of overnight return to work orders, and a lot of employees have voted with their feet. But in the South African, not aware of any on that scale, and it's very much been on a case-by-case basis, aligned with kind of the case that Nadine took. It's certainly very possible in our view where it's not a contractual right to return to work from home, to require employees in our workforce. But I think what we just would emphasize is that rationality, reasonableness, and how you communicate it. And then ideally there's that opportunity to do consult, even if it's informally, just the feedback. But yeah, any of the other panelists come in, but I don't think we've got kind of any of those cases where it's wholesale been found to be unreasonable or employees have all refused. Over to you, Louay, for the poll.
Yeah, I think the poll reflects what we feel, and what the judge also referred to, is that under these circumstances, we're 50-50. So as the judge said, another reasonable decision maker may have arrived at a different outcome. And our results show 48% plays 52%. So very interesting. Thanks, Helen.
Thanks, Louay. Roz is going to take us to our next two cases. Roz, a partner in our practice here, is very familiar to all of you who are regular joiners to the ELU. The first case, I think, highlights, an AMCU case highlights the fine dividing line between dismissals for participations in unprotected strikes and misconduct committed while on strike. So that's the first case. And then the second case that Roz is going to take us through is a lesson on the perils of using retrenchments as a smokescreen for exiting employees. Thanks, Roz.
Thanks, Helen. Good morning, everyone. So the first case I'm going to be speaking on is AMCU on behalf of Matabele versus the CCM and others. So facts of the case are essentially as such. The employer in this case had a contract at West Coal to provide excavation services. They actually had come in prior to the termination of the previous service provider's contract because of a violent strike. So you can imagine that there was quite a lot of sensitivity around strikes and a concern about ensuring that they retain their contract with West Coal. There had been some disciplinary action taken against two employees. One of them was just an employee, the other was a shop steward. And both employees had gone to a disciplinary hearing. The reasons are irrelevant for present purposes, and they were ultimately dismissed. The workforce was incensed by this. They were very unhappy, and they downed tools and embarked on an unprotected strike. And the demand was that these two employees not be dismissed. The employer entered into a collective agreement with the union, in terms of which it was agreed the employees would go back to work, and these two dismissed employees would be given an opportunity to appeal their dismissals. So it was one where there was an automatic right to appeal, and in order to bring the strike to an end, the company gave that right. So all the employees returned to work. Following the return to work, and approximately a month or two later, 4 employees who participated in this unprotected strike were dismissed. They had been charged with acts of misconduct committed during the unprotected strike. They'd had a hearing, they were found guilty, and they were dismissed for this misconduct. They all happened to also be in leadership roles in the union. Now, the reason for this dismissal was this misconduct during the unprotected strike. It wasn't for participation in an unprotected strike. And they were dissatisfied, and the union referred a dispute to the CCMA and ultimately went to the CCMA to arbitrate the dispute on the basis that it was a dismissal for misconduct. Now, I'm sure most of you know, on this call, know that where a dispute is about standard conduct, it goes to the CCMA, and the CCMA has jurisdiction. Where the dispute is about participation in an unprotected strike, then the Labour Court has jurisdiction. Arbitration proceeds. The commissioner hands down his award, and he finds that the dismissal of these 4 employees was substantively and procedurally fair. The union then took this on review to the Labour Court and essentially raised 4 issues. The first was 3 issues. The first was that there was no jurisdiction. The CCMA did not actually have jurisdiction, even though they had referred the dispute to the CCMA. They said, look, ultimately, the commissioner refers to this as being about, or refers to the fact that these employees were engaged in an unprotected strike. And therefore, in terms of section 191, subsection 5, if I'm not mistaken, that sort of dispute must go to the Labour Court. The second was a consistency challenge. The union and the employees claimed that there was an inconsistent application of dismissal. And then thirdly, they said, look, in any event, they are not guilty of the conduct that they were charged with. So in essence, those were the 3 issues that the employer was required to, at least that the court was required to consider. So on the issue of jurisdiction, some of you may recall, but the wording of the Labour Relations Act is such that it says that the Labour Court has jurisdiction if the reason for dismissal identified by employees is related to unprotected strike action. So there is the wording that almost gives the employee or the referring party the decision on how to frame the case. What they did in that regard is it cannot be, or if ever have been, the intention of the legislature to enable a party to effectively forum shop and choose which forum it wants by the manner in which it describes its belief of the reason for dismissal. So the CCMA is still enjoined to determine the true nature of the dispute. And if the true nature of the dispute is about general misconduct, then the CCMA has jurisdiction. If the true nature of the dispute is about a participation in an unprotected strike, then the CCMA must rule that it doesn't have jurisdiction. So the court looked at, well, what was this dispute actually about? And the court accepted that the employees themselves said that they were dismissed for misconduct. They never claimed have been dismissed for participation in an unprotected strike. The employer confirmed this, and the evidence led was about the misconduct committed during the unprotected strike. It wasn't about whether they embarked on an unprotected strike. So the court said the CCMA was correct, they had jurisdiction, and accordingly the arbitration could continue. Then the court turned to the issue of consistent application of discipline. I think we all know on this call that it is trite that an employer is required to act fairly in relation to employees, which includes treat like cases alike. But that does not mean that every instance where employees commit seemingly the same misconduct, that they're treated with the same treatment by the employer. So what the court highlighted is the need to consider all the surrounding factors. You can't be malicious, capricious, or arbitrary, and if a decision is any of those, it is likely to result in an inconsistency finding and an unfairness finding. But what the court said is it is not unfair to treat people differently if you look at the circumstance you can objectively distinguish. And the example used was late coming, for example. So if you have an employee who is habitually late for work, employee has a final written warning and has been cancelled, whatever the case is, again comes to work on Wednesday and is 2 hours late. And you have an employee who also comes to work on the Wednesday and is 2 hours late. On the face of it, they've committed the same misconduct. But you've got a habitual late, and you've got an employee who, let's say there was a motor vehicle accident and could not get to work on time because of surrounding circumstances. And the court said cannot be expected to treat both employees the same and say, well, we're going to either dismiss them both or we're going to give them final written cases. That here you have a valid and justifiable reason for differentiating between the two. So very important on issue. What the court said in this case is that the commissioner just didn't deal with the issue of inconsistency. Now, I think the employer tried to claim that the union and the employees didn't raise the consistency challenge in the arbitration, but the record showed that they actually did do so, and the commissioner just didn't deal with it. And on that basis, the court found that the finding was unreasonable. Court then turned to consider the merits of the case and essentially took issue with the way in which the award was drafted. Now, it is trite that the court does not expect an arbitrator or a commissioner of the CCMA to write an award akin to a Supreme Court of an appeal judgment. But what the court, or at least what the CCMA is required to do, is adequately provide for their decision, to show that they've applied their minds to the evidence, to the law, and reached a reasonable conclusion. In this case, what had happened is that the CCMA commissioner just didn't give reasons for his findings. So as an example, there were conflicting evidence by the witnesses, and the commissioner simply accepted employers' witnesses and the employer's evidence without doing a credibility assessment. So without saying, why do I, as the find that this evidence is credible and should be preferred to the employee's evidence. The commissioner just said, I accept the employer's evidence as credible, reject the employee's evidence as uncredible. So the court said you can't do that. You need fairness dictates you explain why you preferred the employer's evidence. So this as well, the court found that the award was unreasonable because there was no coherent analysis. So say is on the inconsistency challenge, the employer may well have had solid and good grounds for finding, at least for treating differently. But because the CCMA didn't properly consider that and provide reasons, the court couldn't accept that. And then the award was also incomplete, the record was incomplete. So the judge couldn't himself look at the record to see, is there evidence before the arbitrator renders the outcome reasonable? So for that reason, the court said the employees were entitled to receive coherent reasons for the arbitrator's finding, and the award was reviewed and set aside, submitted to the CCMA for a hearing de novo. Now, the lessons in this, just on the jurisdiction issue, be determined on the true facts of the case, not on how employees or an employer might seek to dress the case up. So the commissioner is enjoined to look at what is the true reason. And that is what, goes to the jurisdiction. On the consistency issue, please remember when dealing with cases that may on the face of them look similar, look at all the factors. And if you believe that it is fair to distinguish between cases where the misconduct on the face of it may look the same, ensure that you have fair and objective reasons to do so and that you can sustain those, because that is what you will be required to do if you face inconsistency challenge in the CCMA. So what is your reasoning? The minute it is found to be capricious, arbitrary, or malicious, then that will go to the fairness and your dismissal will be found to be unfair. And then also when it comes to just dealing with the facts, ensure that your evidence is led coherently, it's consistent, that you very carefully set out in your closing submissions or your argument why you say your witnesses should be preferred to the employee or to the other party's witnesses. Here, what you want to do is really assist the commissioner as much as possible to write an award that sets out the reasons, because what you don't want is to find that the award is lacking, and then that is on its own a ground that it has to back to the CCMA. It is also probably worth carefully scrutinizing awards that where a commissioner hasn't given coherent or consistent reasons, rather than spending money on a review application, you might actually be at least consider whether you should agree to the remission of the award to the CCMA. All right, so that's the case of AMCU. Now, the next case, and I'm going to try and pronounce the name, it's Mqikela versus Presto Response Trading. This case, as Helen said, is an automatically unfair dismissal dispute. What happened in this case was the company has a director, sole owner. The HR manager who was employed in the Pretoria branch of the company had lodged a grievance. So she had raised issues about lateness of her salary increase. So when she'd started employment at the company, it was agreed that she would get a salary increase at the same time as a certain other category of employees. This didn't happen. 8 months later, she hadn't a salary increase. She said there was victimization. She wasn't being treated the same. Then there was a whole issue about payment of bonuses, where the staff, including her, hadn't received their bonuses that they were entitled to in terms of their contract. So she had raised a grievance with her line manager, and the grievance was against the director. And her line manager kept fobbing it off and saying, oh, the director's really busy. He can't deal with this. He can't deal with this. Long and the short of it, 12 months later, the grievance hadn't been dealt with. The HR manager then approached the external labor consultant who regularly did work for the company and raised the issue. So the labor consultant then came in and said to the director, there's been this grievance. I should be the one to deal with it. We need someone impartial. And he recommended one of his colleagues to deal with the grievance. The director simply said, not interested. I'm not dealing with the grievance. And that was that. Out of desperation, about another 2 months later, the employee referred an unfair labor practice dispute to the CCMA, where she claimed unfair treatment relating to the provision of benefits. The day after she claimed she submitted the referral, Mr. Lowe, the labor consultant, came to her and said, oh, just so you know, the company is considering retrenching you. And about, I think 2 weeks later, they issued a Section 1893 notice. Now, the timing of this doesn't look good. Let's be honest about that. The timing just looks very, very suspicious. 2 consultation meetings were held. During the consultations, the HR manager said, I believe the true reason why you are trying to retrench me is because I've lodged this unfair labor practice dispute, because of my grievance, and then the unfair labor practice dispute that I've lodged with the CCMA. There was no real response to it, and about a month and a half after the 189 process started, the HR manager was retrenched. Now, the reasons for the retrenchment were ostensibly that the company wanted to outsource the HR function and didn't feel they needed an internal resource, and they had lost an contract, And so they were in financial difficulties and needed to downsize. Interestingly, however, although they needed to downsize and had lost this big contract, they only considered retrenching the HR manager, and she was the only one retrenched. So none of the workers, the people on the actual ground who were no longer working contract, were touched. The employee then approached the Labour Court, and she claimed that her dismissal was automatically unfair. She originally sought compensation equal to 24 months remuneration, but she later changed it and sought compensation equal to 20 months. The employer opposed the claim, and the employer maintained that her dismissal, or the true reason for her dismissal, was her retrenchment. But in its pleaded case, the employer departed somewhat from the rationale that was given to her during the consultation process. So you'll recall the rationale was they wanted to outsource the HR function, and then there was the loss of the contract. The pleaded case and in the evidence, the employer said, well, actually, you know what? We don't need an HR function in Pretoria. We just don't need it. So the position is really redundant. So the court was actually faced with two contradictory reasons for retrenchment, which was one of the first issues that raised the error of the court. The court also then looked at the timing. So the director testified in court. The director said, well, actually, I contemplated retrenchment in September the previous year. That was when this first started, and I discussed it with the employee. The employee denied this and said, this was never discussed with me. The first I heard of it was the day after I referred this unfair labor dispute, and that is what the documentary evidence also supported. The court was also then concerned because the court analyzed the versions of the employer. Even with the timing, the employer kept changing. So the employer said that they lost the contract in September, and that's when he started retrenchments. But on the actual evidence, the contract was lost in June the previous year. So the court was called upon to balance the different versions, and ultimately found that because of the inconsistencies in the employer's version, that the witness wasn't credible and the version wasn't credible. And ultimately, the court found that they preferred the employee's version. So what they look at is what was the proximate or legal cause of her dismissal. And the court said, well, when you look at the fact that actually the whole operational requirement claim is undermined by the differing versions of the employer, and you look at the timing with which they raised this retrenchment, the proximate cause was her referral of a dispute to the Labour Court, to the CCMA. And they then applied the but-for test. So but for her having referred this dispute, she wouldn't have been dismissed. Ultimately found that that was the reason. Now, when it comes to an automatically unfair dismissal, what the Labour Act provides is if you dismiss an employee for seeking to enforce any of their rights under the Labour Relations Act, then the dismissal is automatically unfair. And then what they had to look at is what was the employee's claim? Was it that she lodged an internal grievance, or was it that she referred to the CCMA? Now, there is a Labour Appeal Court case that says that lodging a grievance is an internal matter. It's not seeking to enforce your rights under the Labour Relations Act, and in that case, there wouldn't be a claim for an automatically unfair dismissal. This was distinguishable because the employee had actually referred a dispute, and it was the referral of the dispute that triggered the Section 189 process. So the court was satisfied that the real reason for the employee's dismissal was that she had referred, that she sought to enforce her rights under the Labour Relations Act. What the court also said is there doesn't actually, so even if her labour practice claim was ultimately without merit, as long as it wasn't malicious or vexatious, that is enough for it to result in an automatic dismissal. So please bear that in mind. If you have a similar sort of case where you say there is no merit in the practice dispute, that is not the test. The test is, was it reasonable? Was it legitimately believed? Even if it was, even if it wasn't objectively sustainable, as long as it was in good faith, that is enough for it to be problematic if you then seek to dismiss. Now, as a sign of the court's displeasure, the court awarded compensation equal to 20, so high compensation award. And in considering this, the court was of the view that the employer deliberately manufactured the reason for dismissal because they knew that they didn't have a fair reason to dismiss otherwise. The employer falsified the reasons. The employee was still unemployed as a result of the employer's conduct, and the employer came to court with plans. So the court also granted costs in the labor court, which is not something we see very often. So the lessons case. If you are going through a retrenchment, please make sure you have clear, cohesive reasons. So you set out your operational and cohesively. Anything you want to rely on later in court, make sure it's part of the consultation, it's part of your justification. The court is not afraid to scrutinize operational requirements and make sure that there are valid operational requirements. The court is also not going to just take. And if you are using retrenchment because you think it's easier than a performance management process or an incapacity process, do it. You need to ensure that you actually have operational requirements before you dismiss. The court will view dimly an attempt to dismiss an employee for alternative reasons. Don't misrepresent the true reasons for dismissal. Employees who deliberately disguise a dismissal before the labor court and to mislead the labor court will be viewed with a jaundiced eye by the court. And the other thing that isn't dealt with in this case is because the employee was retrenched, there are tax implications. And if it's not retrenchment, then you run the risk of being seen to be defrauding SARS. So all of those issues should be borne in mind at dismissing employees and the rationale for your dismissals. Thanks very much, Helen.
Thanks, Roz. Yeah, that's applying test. When you're doing the operational requirements, how's this going to play back in hindsight to a court is always so important. I do think one interesting scenario this quite often is that you'll have the scenario of an employee who is a poor performer, and because they're a poor performer, it shines a spotlight on the fact that the employee actually doesn't need that role within the organization. So it starts off as a performance issue, but it highlights that actually, do we actually even need this role? Which I think is, you still have to be very careful there, but I think it's sometimes a different issue from the one that this case highlights. But yeah, there can be quite a few permutations. We move on to our next case dealing with retrenchments. I just want to return to Nadine. We had two additional questions there relating to remote working. So I don't know if you would just like to quickly address those for us.
Perfect. Thanks, Helen, and thanks very much for the questions. So we have two questions really about revoking remote working and whether your application of reasonableness would surpass this requirement, and also in respect of obviously regulating core agile working hours, and if you want to sort of grandfather certain employees on these arrangements, but not everyone. So I think generally in response to those two questions, obviously the starting point, as mentioned, would be if working arrangements constitute terms and conditions of employment, or it is a sort of benefit provided in the workplace. Of course, if it is contractually agreed up front that someone will work remotely, hybrid-wise, you would ordinarily need to engage and get their consent to change it, failing which you may find yourself in a breach of contract claim or certain risks there. In respect of a benefit, and to the first question, which is ordinarily how the working arrangements have taken place. It takes the form of a workplace policy, which grants the employer discretion or, to amend it or change it to actually revoke the policy. But even if the employer has a right to revoke this policy or benefit with immediate effect, you are correct that there is this requirement to be reasonable. An employer doesn't have an unfettered discretion in the manner in which it can regulate a work benefit. So any sort of change to that would need to be done in a manner that is reasonable, it's consistent amongst employees, and it is rational. So in those circumstances, you'd still have a requirement to make sure there's an objective rationale for it and it's reasonable, and also to follow procedural fairness in terms of consulting with the employees and allowing them an opportunity to provide representations before changing that. The risk there, if you don't, is of course an unfair labour practice potentially can be claimed, in that the sort of benefit was revoked without the employer complying with the principles of equity and fairness. Kim, in respect of your question, specifically grandfathering employees, this is a difficult one, and I think it goes back to the same principle that any sort of action the employer takes must be reasonable and rational relating to the circumstances. So provided that you can justify it with reference to certain employees' roles or duties, with requirements in terms of how they operate and the arrangement being put in place, the concept of grandfathering can be justified, but one would need to assess it on a case-by-case basis. If two employees are performing the same role and one can work sort of on a hybrid basis and the other one has to come from the office, you would need to have a justified reason as to why that's the case in that circumstance, and that is sort of applied fairly across the employees. So it really comes down to being fair, being rational, being consistent, and ensuring that sort of process is followed with the affected employees. Helen, I don't know if you have anything to add there.
No, thanks, Nadine. That's great. Hopefully, I think that's addressed those questions. Moving into the final stretch, everyone, our last three cases. Lenia, one of our partners and who's also one of our award specialists, is going to take us to the next two cases. The first one is, I think, what can only kindly be said, an incredibly creative use of retrenchment. And I think the outcome of the case was very predictable. So Lenia will take us through that, following on from the same theme that Roz was speaking to earlier. And then there's a second case, which will go straight into, looks at reinstatement orders, and when there is an order regarding back pay that is challenged, what then comes as applicable payment date. Thanks, Lenia.
Thanks, Helen. Good morning, everyone, and thanks for joining us. So the first case I'm going to discuss certainly has parallels to the one that Roz just discussed, in the sense of what is the real reason for the retrenchment and the sensible operational rationale for the retrenchment. So this is the case of Oily SA versus Cholak, and it offers valuable lessons for employers navigating the terrain of operational requirements dismissals, but specifically where there are changes to employment contracts, and in this instance, changes to restraints of trade. So let me begin with outlining the facts. As you may guess, Oily SA is a company operating in the oil and lubrication sector. In 2022, after a senior employee had left and allegedly solicited the company's clients and employees, Oily SA took the decision to take steps to protect its business by amending all employment contracts. Specifically, what it did is it amended the contracts to include significantly broader restraint of trade provisions than were previously in place. So there had been restraints, but they basically aimed at beefing up these restraints. They did that by extending the restraint to the whole of South Africa for a period of 24 months, as opposed to previously a shorter duration and provincial restriction. And crucially, they removed unilaterally the provision for compensating employees during the restraint period. So they removed the restraint of trade payment. Mr. Cholak was an ex-employee and the respondent in this matter. And he was the only employee out of 15 who refused to agree to and sign the new contract. He objected to the expanded scope of the restraint and the removal of the compensation for the restraint. Oily SA engaged with him and ultimately wasn't able to reach agreement with him to sign the restraint. But what it did is it ultimately ended up retrenching Mr. Cholak, citing operational requirements. and specifically the need to protect its economic interests. So as you'll be aware, it is permissible to embark on retrenchment proceedings on the basis of an employer's economic, technological, structural, or similar needs. But interestingly, in this case, Oily SA approached the retrenchment proceedings on the basis that the refusal to sign the restraint detrimentally impacted its economic interests. So this wasn't an instance, as is typically the case, where it was, economic interests in the sense of a cost-saving exercise or profit-enhancing exercise. Mr. Cholak challenged his dismissal at the CCMA, arguing both substantive and procedural unfairness. At the CCMA, the Commissioner found in his favor, and Oily SA took the matter on review to the Labour Court to set aside the award. However, ultimately, the court sided with the CCMA and dismissed the review, upholding the arbitration award. So insofar as the legal issues are concerned, there are two main issues at play. The first was the substantive fairness of the dismissal. The question was whether Oily SA had a genuine substantiated operational need to retrench Mr. Cholak, or whether the retrenchment was simply a response to his refusal to accept new, more onerous contractual terms. Secondly, the procedural fairness of the process. Did Oily SA follow the requirements of Section 189 of the Labour Relations Act, which mandates a meaningful joint consensus seeking process when contemplating retrenchments? The court also considered the conduct of the Commissioner at arbitration, which Oily SA had taken particular exception to. And this was because the Commissioner had involved himself and played an active role in questioning the parties during the CCMA proceedings, given that both parties were unrepresented in the proceedings. So if we unpack the court's findings, on substantive fairness, the court was clear. An employer must provide clear, substantiated evidence of a genuine operational need to retrench. In this case, Oily SA's justification was vague at best. They referred to unspecified risks and potential losses, but failed to present concrete evidence of actual or even potential economic harm arising from Mr. Cholak's specific refusal to sign the new restraint. They also didn't demonstrate why the expanded restraint was in fact necessary, nor why the compensation provision was removed from the contract. On these bases, the court found that the employer's operational rationale was unsubstantiated, and accordingly, the dismissal was substantively unfair. On procedural fairness, the court found that Oily SA did not follow a meaningful consultation process. Specifically, Mr. Cholak, during that consultation process, had made various counter proposals for alternatives to retrenchment, and also the proposal to retain compensation for the restraint. But these weren't properly considered by Oily SA or even formally rejected by them as an alternative to retrenchment. The process was, in essence, a fait accompli decision and a mechanism to avoid having to pay Mr. Cholak the restraint payment rather than a genuine attempt to seek consensus and engage meaningfully in that process. Insofar as the Commissioner's conduct was concerned, the court affirmed that the LRA empowers the Commissioner to conduct proceedings as they see fit, especially where the parties are unrepresented. The Commissioner's active questioning was not in and of itself misconduct, but rather it was necessary in the circumstances to ensure that the real issues were ventilated between the parties, they were appropriately addressed, and because they were unrepresented, that both parties were appropriately assisted during the proceedings. So what does this mean for you as business leaders and HR professionals? So firstly, substantiate operational requirements. If you are contemplating retrenchments based on operational requirements, especially where the issue in play pertains to an employee's refusal to accept new contractual terms, you must be able to demonstrate with evidence, a genuine operational rationale. Vague references to risk or potential harm aren't going to suffice. You need to be able to show why the change is necessary, what losses you anticipate, what risks exist, and why alternatives aren't viable in the circumstances. Secondly, you need to be able to justify your restraints of trade. So if you want to introduce or expand a restraint of trade, be prepared to justify its scope, its duration, its geographical reach. If you remove compensation for restraint, you need to be able to explain why. The courts have been clear that overly broad or punitive restraints without clear justification aren't going to withstand scrutiny. Engage in a genuine consultation. As we all know, Section 189 of the LRA is not a tick box exercise. You must engage in a meaningful joint consensus-seeking process. And this means considering counter proposals, responding to them, and importantly, documenting your engagement in the proceedings. Failure to do so exposes you to risks of potential procedural unfairness. And then also just bear in mind the role of the commissioner in these proceedings. If you find yourself in an arbitration where the company isn't represented or the employee isn't represented, understand that the commissioner is empowered and indeed obliged to assist both parties in ventilating and exploring the real issues. This is not in and of itself a bias, but it's a safeguard to ensure fairness in the proceedings. So in summary, this case is a cautionary tale. It reminds us that operational requirements dismissals must be rooted in genuine, demonstrable business needs, and that the process matters as much its substance. It also affirms the active facilitative role of commissioners in arbitration proceedings. So when you consider changes to contracts or you consider possible retrenchments, ensure that your processes are robust, your evidence is clear, and your engagement with employees is genuine. It's not only a legal imperative, but it's one that will save your company from costly litigation and reputational harm. The second case I'm going to discuss is a recent decision by the Constitutional Court in the matter of Mavundla versus Gotcha Security Services. And as Helen indicated, this deals with reinstatement with back pay to the date of dismissal. So by way of background, Mr. Mavundla was employed by Gotcha Security Services as a VIP protection officer. In March 2019, he was dismissed. He challenged his dismissal at the CCMA, which in July 2019 ordered his reinstatement with effect from 1 August 2019. So the date that's important for these purposes is that 1 August 2019 date. And the CCMA also awarded him back pay for the period from his dismissal until the reinstatement date in the region of about 50,000 Rand. However, when Mr. Mavundla reported for duty on 1 August 2019, the company refused to accept his return, and the basis on which it did so was to say they're contemplating launching review proceedings. Notably, the review proceedings never materialized. Over a year later, in September 2020, the employer invited Mr. Mavundla back, but they made it conditional. They said, you can come back if you provide us with a valid firearm competency certificate and industry registration. Mr. Mavundla disputed these conditions, arguing that they were not part of the original CCMA award that had reinstated him. So this generally led to back and forth between the parties, and the impasse led to contempt proceedings in the Labour Court being launched by Mr. Mavundla. The contempt proceedings in and of themselves didn't proceed in the court because what the court did is they instructed the parties to sort of step down, engage with each other in an attempt to resolve this matter amicably. And what the Labour Court did there is ultimately order Gotcha Security to reinstate Mr. Mavundla unconditionally from 1 June 2021 on the same terms as before his dismissal. So effectively, this order reinstated him 2 years later after the original order of the CCMA to reinstate him. Again, Mr. Mavundla returned to work, but as he did that, he claimed area remuneration for the period from 1 August 2019 to 31 May 2020, being the period during which he was unable to work despite the reinstatement order. The company refused to pay him the back pay, and the matter ultimately escalated through the courts again, culminating in the Constitutional Court's recent judgment. So if we turn to the legal issues at the heart of this case, the central question was, is an employee entitled to area remuneration from the date specified in a reinstatement award, even if the employer delays actual reinstatement? So when the matter went to the Labour Court, it initially held that Mr. Mavundla was only entitled to remuneration from the date he was factually or actually reinstated, and that was 1 June 2021, arguing that until the employer accepted his tender of services, no contractual obligation to pay the salary existed. The court continued to, it also reasoned that the subsequent order, so that was the one in the context of the contempt proceedings, which set a new reinstatement date, effectively replaced the original reinstatement award of the CCMA, and by implication, any entitlement to back pay. Also, what the court found is that by conducting himself in accordance with the order, the latter order, Mr. Mavundla had effectively waived his entitlement to back pay. When the Constitutional Court considered this matter, it took an entirely different view. It clarified that an order enforcing a reinstatement award does not automatically replace the original order for the purpose of area remuneration or back pay, unless it expressly limits the entitlement to back pay. The only thing that changes in this context is the date on which the contract of employment is actually reinstated or restored by mutual agreement between the parties, and that occurs by tender and acceptance of services between them. The Constitutional Court emphasized that unless the enforcement order specifically says otherwise, the employer remains liable for remuneration from the original reinstatement date, which in this scenario would be the 1 August 2019 reinstatement date. In other words, the employer's refusal to accept the employee's return, especially where it wasn't justified by a valid legal process. As you'll recall, there was no review process that was reinstated, that was pursued, does not relieve it of the obligation to pay area remuneration to the employee. The Constitutional Court found that Mr. Mavundla was entitled to his salary for the entire period that he was obstructed from working, and that was from 1 August 2019 when he was dismissed until 31 May 2021 when he was factually reinstated. So what are the practical learnings here? First and foremost, when an arbitration award or court order reinstates an employee with effect from a specified date with back pay, the employer is required to pay remuneration from that date, even if the actual reinstatement is delayed as a result of the employer's conduct. Importantly, if any further order is made to enforce the original reinstatement order, this does not in and of itself replace the original order for the purposes of the area remuneration element, unless the new order expressly confirms that there is no entitlement to back pay or there's some sort of limitation on back pay. The only aspect, like I've said, that changes is the date on which the employment relationship is restored in practice, which occurs when the employee tenders their services and the employer accepts the tender. Secondly, employers need to act promptly and in good faith when dealing with reinstatement orders. If there are genuine concerns, such as regulatory requirements in this context on the basis of the security industry, or a legitimate basis on which to institute review proceedings, these should be addressed transparently and expeditiously, and attempting to oppose new conditions, such as the firearms certificates and the registration with the security body, after the fact of the reinstatement order, or using other technical hurdles to delay reinstatement, is not only risky, but as this case shows, can be costly. Ultimately, this case underscores the importance of compliance, clarity, and good faith in employment relationships. Employers should not assume that delays or conditions imposed after a reinstatement order will shield them from liability for back pay. In fact, it can just have the adverse consequence of doubling back pay because of the duration of time. Thanks for your attention, and Helen, I'll hand it back to you.
Thanks, Tanya. Yes, it can get very costly. Before we round out with Luay taking us through the last case dealing with protected disclosures and what is a protected disclosures for the purposes of the Protected Disclosures Act, I just want to address the last question in the Q&A. You can see there's lots of interest about remote. I think this is something that we are all battling with as employers and facing these type of questions. So from Clinton, his question is, if an employee is away from their primary place of work, which I presume means in terms of the contract, for example, they've moved to Cape Town when the normal office is in, for example, Johannesburg, then it's necessary for them to be in the Johannesburg office, their normal place of work, upon kind of a requirement to return to work. How do you approach that? We're seeing lots of these queries. It can be tricky. I mean, to Nadine's point, the first thing you need to really understand is, was there agreement for them to relocate, and what were the terms of that agreement? Because if they were allowed to simply relocate to Cape Town and that's where they're doing their role, then you're in the realm of agreement that you have to reach agreement. The other alternative then you need to start looking at is it a Johannesburg-based role? Does this become an operational requirement? Obviously, it's quite tricky when you start looking at a potential redundancy process based on location. So the first thing is to check, was this agreed, and what were the terms of the agreement? If it was not agreed, it was kind of a discretionary call, or the employee is almost just silently migrated, or it was in terms of a policy which was very clearly a discretionary policy and could be amended, then I think we're back into the realm of the cases that we discussed, requiring them to come up. Is it a reasonable and lawful instruction? And that's very fact specific. We've had instances where clients have done that, and employee has ultimately complied. So giving a real lawyer's answer on that, it's a very fact-specific one, depending on what was agreed. And it just underscores that policy where kind of managers are kindly just agreeing this in a very flexible manner, either verbally or by a very informal email that can come back to you. So you want a clear policy on that. This is our remote working policy. We can amend it. We can withdraw consent that was given, etc. I know that is not always helpful when you're dealing with the problem now, but yeah, hope that very high level addresses your question. Thanks, Luella.
Thanks, Helen. I'm going to close out on a case about, as Helen mentioned, protected disclosures and occupational detriments. I think we're seeing also quite a bit of lots of clients coming with queries in relation to this, as we see an increase in whistleblowing, anonymous whistleblowing lines, and employees then raising it as an issue if they are thereafter subjected to either disciplinary action or other action, suspensions, or any action of that nature. So this is the case of Ramela versus Cooper NO. It's a High Court case. The matter could also have gone to the Labour Court given the subject nature, and it's an urgent application for protection in terms of Section 4 of the Protected Disclosures Act. Now, I just want to very briefly touch on what is covered in terms of Section 4. It relates to protected disclosures. Protected disclosures are defined in terms of the Protected Disclosures Act. It's first and foremost a disclosure, which is defined as a disclosure of information regarding any conduct of an employer, which shows one or more of the following. And I'll just touch on one or two of them. It's that a criminal offence has been committed, or is being committed, or is likely to be committed. That a person has failed, or is failing, or is likely to fail to comply with any legal obligation to which that person is subject. That a miscarriage of justice has occurred. So that's the disclosure, and then it becomes a protected disclosure depending on to whom it's disclosed. And then Section 4 of the Protected Disclosures Act, and I think this may be relevant to another provision, which I'll touch on a bit later, relates to the remedies available. And essentially, an employee can approach a court, including the Labour Court, if the employee feels that the employee is being subjected to an occupational detriment. And again, occupational detriments are defined in terms of the Protected Disclosures Act, but as I mentioned, the primary ones are often disciplinary action, maybe suspensions, and there's a couple of others being transferred and similar kinds of acts. So background to this matter was that the CFO of Robben Island Museum had been appointed in terms of a fixed-term contract on the 1st of June 2023, and it had come to Robben Island Museum's attention. They'd received a letter from the National Treasury reflecting an outcome of an application that I'm going to say RIM, Robben Island Museum, had submitted to the Treasury to condone the irregular procurement of a boat estimated at 90 million rand without the application of the 90-10 preference point system. So essentially a procurement irregularity. And National Treasury declined that condonation application because RIM hadn't conducted a determination test as it was required, or an investigation as prescribed by the National Treasury. And so what followed thereafter, RIM established a Fraud, Risk and Loss Control Committee in order to conduct the determination test. The CFO was ultimately asked to assist with that determination test. And then what occurred thereafter was that after compiling the determination test, the applicant said that there may be security risks due to the procurement issue, the profile of the organization. And so what he did thereafter was that he filed an affidavit at the SAPS in December 2024, raising some of these concerns. What transpired thereafter was that it came to the employer's attention, RIM, that there were certain concerns about his qualifications, whether he had misrepresented certain qualifications. But, and this timeline is important, around the 4th of February 2025, he then decided to consult with his counsel about the possibility of bringing an application in terms of the PDA. Around the 12th of February 2024, he was then suspended. And on the 14th of February 2024, he then deposed to a supplementary affidavit, which he then referred to the Minister of Sports, Arts and Culture. Now, following his suspension and this disclosure, he was subsequently charged or invited to make representations in April. On the 15th of April, he was issued with that notice, and he was required to attend a hearing on the 7th of May 2025. And he then launched this urgent application on the 22nd of April 2025. So just to, and I'm mindful of time, he was suspended on the 12th. On the 14th, he then provided his, what he relies on as his protected disclosure to the Minister of Sports. And then on the 15th of April, he's issued it to invited to make representations. On the 22nd of April, he then launches this urgent application. And the court then looked at whether or not this then amounted to a protected disclosure that required protection in terms of the Protected Disclosures Act. And one of the first things they looked at was around the urgency. And we're not going to go into too much detail on that, but essentially the court held that the urgency was self-created, bearing in mind that he had made the disclosure that he relies upon in February, but only brought this shortly after he'd been issued with the notice to attend his hearing 2 months later. So that was one of the issues that the court looked at. But they said for the purposes of being comprehensive in the matter, they will actually deal with the other aspects as well. And so one of the things that is required in terms of a reliance on a protected disclosure and being subjected to an occupational detriment is that it must be made in good faith. And the court stated that there's a number of factors that one must look at when looking at this application of what constitutes good faith under each circumstance. And they said for good faith to exist will depend on the circumstances. There must be an absence of bad faith, which will usually be where there's a corrupt motive or dishonest intention. From other case law, we're also mindful that just because the disclosure doesn't turn out to be true doesn't in itself make it bad faith. But good faith will depend on a number of factors. And in this instance, what the court found and what is important as takeaways in this matter was that first of all, the information that was being disclosed was already information that was known by the employer and in the public. And so when the disclosure was made to the Minister of Sports, it was around primarily this procurement issue, which was already known. And the court said that but disclosure cannot be information that is already known to the party to whom it's disclosed. The second aspect was that the court said there must be a causal nexus between the disclosure and then retaliatory conduct. So in the event that he was being invited to attend a disciplinary process, then it was in response to the fact that the disclosure was made. And they said that that wasn't present in this instance. And in support of that, they relied on the fact that he was suspended on the 12th of February, 2025. He only made the disclosure 2 days thereafter. And then the third element that they also took into consideration was that he brought this just before his disciplinary hearing. And so they read into that his motive was actually an intention to delay the disciplinary process, and that it wasn't a genuine attempt or reliance on being subjected to an occupational detriment. And so on that basis, his application was dismissed. And I think this good faith requirement's important. I think that employers are also facing often or increasingly, there's been this reliance on Section 188A11, whereby internal disciplinary processes may be referred to the CCMA for determination, and employees then rely on this claim of a disclosure in good faith. And so I think these factors are going to find increasing reliance and consideration by employers. And so that's, in a nutshell, the case. I'm mindful that we've just run over time, but this element of good faith in protected disclosures is certainly an issue, and this court dealt with it very well.
Thank you, Louay. Thanks to all the panelists, and thank you to all of you for joining. It's been a pleasure. We hope you found some of the cases interesting and helpful. We look forward to seeing you at our next ELU. Cheers, everyone.